Hello and welcome to Law Unfiltered. I am Jonathan Mason.
And I'm Sonya Madison.
Sonya, there's something I need your expertise on. So I know our viewers need your expertise.
Which one now? Because you always need my expertise.
I do. And I'm sure you know this topic very well. Probably starting in maybe February, March, I started getting these emails because when you work something about entertainment law, it seems like everybody wants to be in entertainment law. And I know going back to when I was in law school, it was tough to get an internship in entertainment law. And if you got one, you could forget getting paid because everybody and their brother wanted to do it, and they could easily find someone who's willing to do it for free. So now the tables have been turned, and I get a lot of emails from law students, even college students, and they're like, they want to come in and work, well, intern, I should say, and they're willing to do it for free. And I'm like, this sounds like a great deal. Look at all this stuff on my desk. Sure, I want to do that, but should I do that?
Probably not.
Come on, Sonya.
No, sorry. But no, probably not. The thing is, the law does define what classifies as an intern and what classifies as a paid or someone who's actually working, performing services for you. And just because you put their title as intern doesn't mean you're actually meeting the law standards. And I get this constantly because I do have a lot of clients that they want to avoid paying employment taxes, or they want to even avoid just paying money in general. And they say, well, I'll just make it an intern because it's a student. And then they don't do anything else. And so what you really need to do after you decide, okay, I want to make this an intern, is draft out truly if that person's going to be an intern. Is it going to be to your company's detriment that you're having this person on staff? Is it going to be an educational benefit? Are you going to ask them to do work that either you do or you've already paid someone else to do? So admin work, if you're going to bring them in to do that, you can forget it. That is an actual worker. You need to pay them accordingly. I know Puff Daddy last year got hit huge in the entertainment industry because he had all these interns that weren't working, or at least weren't classified as employees. But what he was asking them to do was give them coffee, or just those minimal tasks that you don't need to go to school to know how to fetch coffee, right? And B, you also don't need to pretty much go to school just to learn how to watch someone, for the most part, if they're not going to do entertainment type work. So what he was doing is, you're just watching him perform a video, or you're just watching him do something that just isn't, again, up to the curriculum, particularly if that person is there trying to do something that has nothing to do with producing music or to do with what you're asking them to do. So if you don't have an actual program with materials set out to show that, hey, this is why this is to my detriment, I'm going to have to show them, do presentations for them, I'm going to have to train them on all this kind of stuff, and it's going to take so much of my time that it's going to take me away from the actual work that I'm bringing money for, then more likely than not, you just need to hire them and pay the minimum wage or seek an attorney to see what the appropriate payment should be.
But within what you just said, it sounds like I heard if they are a true intern, then you can hire them and not pay them.
Right. The problem is most times they're not a true intern. Just because even after you've done your materials, then what is the practice? And again, the only reason these become issues is because the intern will someday sue, and they're going to say, no, you had these materials saying that I was going to learn about how to do these instructional things that are in the curriculum, but what I actually ended up doing was fetching you coffee, running errands, making copies, all this stuff that an administrative assistant would do. And so that's why we're in this predicament as we are. So just because, again, you've even put it on paper, you got to make sure the execution is there as well, because that's when you get hung up and the intern comes back and says, no, I should be getting minimum wage, overtime, all the stuff that I did.
So where are the guidelines for determining if someone is a true intern or not?
Well, you can go to the FLSA website or the Department of Wage and Hours. It's the U.S. Department site, or I should say Department of Labor, but they have a Wage and Hour division. You can go there. But what you really need to do is seek an attorney, because even if you follow, again, the guidelines to the best that you can, if your execution isn't there, you really need to make sure the attorney is there to audit or to make sure they tell you this is what you really need to look for when you're supervising this individual, or this is what you need to make sure you're doing to fulfill all these checkpoints. And you probably should even get an attorney to review your materials once you've done it to make sure it's truly meeting those characteristics.
does it matter whether they're come on site to your office or whether they work remotely and you just give them an assignment and then they're free to work independently?
It does matter because if they're not on site, then you really don't know what they're doing, right? You really can't supervise to make sure they're following the curriculum accordingly. And if they are on site, again, you have a better chance of monitoring what they're doing and a better chance to show that, look, it was really to my detriment. I had to watch this person. I had to actually educate this person. I had to actually do all this stuff that took me away from my work. And if they're off-site doing who knows what, then one, you're not going to be able to show that you truly were executing the materials. But two, it's harder to show your detriment.
And you mentioned that Diddy got hit hard. What does that mean? Like, who comes down on someone who hires, quote unquote interns who actually aren't interns?
Right. Well, it
Is
could
it
be
the IRS. Is it
both. It could be not the IRS, but it's usually the Department of Labor that will come in and say, hey, you violate labor standards. Or it could be a class of interns. They could all go together to an attorney's office and say, hey, we should have been paid, and that attorney, because attorneys will simply take it in the class type section, will say, okay, we'll file on your behalf. But even it could still be an individual as well, depending on how long the internship is. If the attorney feels as if, hey, this was long enough to where we can get a good demand or a good substantial damage reward, they may take the case. Wow. And you could still get hit with the Department of Labor. I mean, you can get hit simultaneously. If that intern particularly files suit, as well as goes to the Department of Labor, and the Department of Labor decides to audit to see what you've done for other interns, you could be hit with double damages.
Well, it sounds like, that would be relevant to a big organization that's hiring, multiple interns for the summer. But what about just, solo practitioner or single business person? Does the same apply? I mean, clearly you wouldn't have to worry about a class action.
You won't have to worry about class action, but you still have to worry about that intern. We're going back and saying, hey, I wasn't paid and I should have been. And the thing about it is, even if it's a short period, but it's definitely more prevalent with the long period, if you could not show how many hours that person was working, if you're not doing that record keeping, more likely than not, the judge is going to side with that intern. So if you come in and say, you know what, even though I was hit, fine, but you were working 5 hours a week, but you weren't recording those hours, that intern can come back and say, no, I would go home and you would call me, or I would do other research on my own to help with you, so I should be including all those hours. I mean, that adds up when you're talking about overtime in particular.
Okay. So what about this course of action? Instead of, okay, you still want to keep it unpaid, can you work through a school, a university, and say whether they have an established internship program or not? Is it something that you could propose to, we got a lot of universities here in Atlanta, and say, hey, I want an intern. Can they get school credit for it? Is that a different type of
That's
analysis?
actually the best solution. It's the same analysis because, again, if you're getting credit, you're showing there's an educational component that it meets. But that's one of the best ways to show the educational component, because if you get the credit for it, then obviously you fulfill some kind of curricular requirement for a class or whatever that enables you to get the credit. And so that would be ideal. Now, a lot of particularly small companies or entrepreneurs don't have the resources to be able to go to the school and be able to show that it can get a 3 or 4 hour credit or whatever the amount of credit it is. Bigger companies have a lot more leverage to be able to get the credit. But still, that's usually the first thing that judges look at. Is there, some kind of college credit for it, and that usually helps in your favor. Now, just because you don't doesn't mean that you can't then hire an unpaid, or I won't say hire, but get an unpaid internship or intern. But it definitely gives you more leverage in court if you can get college credit.
So, is this something that's recent, like these laws and rules that you're sharing with us? Because it seems like people have been doing this forever. Has it been an onslaught of litigation by interns that now the rules are changing? But what's different now?
No, it's not recent. Usually what's different, and this is when you get to the politics of it. The law has been what it's been for a long time. But a lot of times when you see a shift in the Democrat versus the Republican arena, you get a lot more employee-friendly if it's a Democrat, or employer-friendly when it's a Republican-type, government. So while the law hasn't changed, there have been a lot more litigations within the past couple of years. And of course, I'm speculating that it is because of the change in the political environment, but you do see that a lot not just with interns, but just a lot of employee verdicts in general, because you just have more people focused on the rights of employees versus the rights of employers.
Now, what if we've been using the title intern? I mean, what if it's not labeled as an intern? It's just, I don't know, an independent contractor or what have you. I mean, in most cases, they would probably be paid, but can you run into some of the same problems?
Definitely. I mean, that could be a whole nother topic, honestly, when you bring in independent contractors, because a lot of times they really are employees and you've misclassified them as independent contractors, and you're then going to be set up for damages if you weren't paying them a certain amount, or if you weren't paying them overtime and all this, you weren't paying employment taxes, I mean, you know, all this stuff that comes into play. So now the standard is different. Obviously, what classifies as an intern is not going to be the same as what classifies as an independent contractor, but you do want to make sure you're classifying all of those correctly. And one thing to know is that you can pay, I mean, just because you're paying an intern doesn't mean they're no longer an intern. You can pay an intern, and in fact, you know, once you start paying them above, I guess I want to say 20% of what you would really pay someone to do that job, then they're no longer classified as an intern. So there is a limit or maximum of how much you can pay them, where there's no minimum.
It seems like you wouldn't hire an intern if you're gonna have to pay them
Or you can hire
better than you're gonna have to pay an
I know,
employee.
you just hire an employee, but that's when you start getting to why equal pay becomes a big issue. You know, all this kind of other stuff that people are trying to make sure we're distinguishing. Okay, this is truly an intern, because again, it's to your detriment. Even if I'm paying you, it's still to my detriment that I have you on staff.
Okay. Well, and this is, I'm straying a little bit, but it's a little related at the same time. Like for example, in Georgia, workers' comp insurance requirement is triggered by 3 or more employees.
Mm-hmm.
So is it acceptable / legal for an employer to categorize, they have 10 people working for them, but they're all independent contractors and no employees? I mean, is that a strategy that employers use?
Some may. I mean, a lot of times people put you as independent contractor so they can avoid employment taxes, or they can avoid saying we need workers' comp or other insurance requirements that are met. But again, you're still subject to audit. If anything, you become huge on someone's radar, and that's where a lot of companies get sued, is because someone has filed for a workers' comp insurance claim. Employer says, no, you're not, you know, an employee, so I don't owe you any. And then they sue, say, hey, hold on, I was really an employee. Yeah, we had this agreement, but I was integral to your organization. I was working countless hours. You were my only, and they're going to call you employer, but you were the only person I was performing services for. And then the court is going to make a decision based on all those factors, not based on whether you have an agreement in place.
So is that whether their status as an employee or independent contractor, would that be litigated in a workers' comp claim or in a court?
Multiple claims. I mean, you can, if an independent contractor files a discrimination claim and an employer says, no, you're not subject to Title VII because you're not an employee, we're going to go back and forth on whether that person was an employee. And if anything, you had a slew of independent contractors, the EEOC or whoever is going to look to see whether all of them were in fact independent contractors, or if they were employees. And if they were, it's going to make you more susceptible to being under the Title VII requirements. So it's not just workers' comp, but I'm saying it usually just comes up when that person is ready to sue you. And whether that's because they want to do workers' comp, or whether they feel discriminated against, or whether they feel like they weren't given overtime, whatever they feel as if they're entitled to as an employee, and you argue, no, you're an independent contractor, then those characteristics and that audit comes into place.
Yeah, I know we touched on this, but I don't think I asked it directly. In terms of coming down the Department of Labor or whatever other entity, is it something that an employer would be fined for? Can you go to jail? Like, what are the penalties and consequences?
You're typically not going to go to jail, but you are going to be subjected to huge fines, and that's just going to depend on if they decide to do an audit and see if there's been a history, you know, of people that you have been misclassifying, and if they feel like those people have been doing overtime for you, or if they feel like you've been frauding the government of taxes because you didn't classify them correctly. I mean, that's going to really determine how much your damage is. And I've seen a lot of companies file for bankruptcy after they've been hit with a substantial amount of damage that they can no longer afford.
I see. So the bottom line is, I guess if you're gonna hire interns or independent contractors, you need to
Make sure that's what they
consult
are.
with
Yeah.
an attorney to make sure
Definitely.
that you're in compliance so that you don't get bopped over the
Right,
head.
right, and you do it for years and then all of a sudden they hit you.
Wow, it's good stuff. It's relevant now. We're in the summer now. There's probably somebody out there watching this video saying, "Oh my goodness,
Right,
I
either they're
think I'm
saying,
violating them."
I should be able to get paid, or they're saying, oh my gosh, I've been
I'm
treated
in
as
big
intern.
Right, yeah. So,
Yeah, one or the other.
well, don't get mad at us if someone sues you
If
because.
anything, appreciate us for giving you the information.
All right. Well, that was a good episode, Sonya. Thanks.
Oh, sure, thanks.
Good
Enjoyed talking to
information.
you. Yeah,
All right.
yeah.
Okay. See you next time.